Breaking news from the Ninth Circuit Court of Appeals. The case that could end so-called magazine bans across America has just taken a massive turn. It's called Duncan versus Bonta, and it's more than just a fight over hardware. It's a constitutional showdown over the very definition of the Second Amendment and how far states can go in limiting what they call large-capacity magazines. For years, gun owners in California and across the country have been watching this case, knowing it could set the standard for all future gun regulations. Now, with the latest ruling, the stage is being set for the U.S. Supreme Court to decide once and for all, are magazine bans constitutional, or are they a direct violation of your right to keep and bear arms? In this video, we're breaking down everything. What happened in Duncan versus Bonta, what the court said, why this case is headed for the highest court in the land, and what it means for you, the law-abiding gun owner. This is Firearms.Explained, where law meets liberty. Let's get into it. Balance Scale Part 1. The story of Duncan versus Bonta. To understand what's happening now, you need to know how this all began. Back in 2000, California passed a law banning the manufacture, sale, and importation of magazines holding more than 10 rounds. Gun owners across the state called it unconstitutional, but the law stood for nearly 2 decades. Then came a man named Virginia Duncan, a California resident and gun owner who refused to accept that the state could decide how many rounds she could legally possess. Backed by the California Rifle and Pistol Association, she filed a lawsuit against then-Attorney General Xavier Becerra, later renamed Duncan versus Bonta when Rob Bonta took over. In 2019, U.S. District Judge Roger Benitez ruled in her favor, striking down California's ban as unconstitutional. He wrote, "Individual liberty and freedom are not outmoded concepts." For a brief moment, Californians experienced what became known as Freedom Week, a single week where over 1 million standard capacity magazines were legally purchased before the decision was stayed on appeal. But the state didn't back down. The Ninth Circuit initially upheld Benitez's decision, then reversed itself in 2021, reinstating the ban. After the Supreme Court's Bruen decision in 2022, which changed the legal test for gun laws to rely on text, history, and tradition, the case was sent back down again. Now, after years of back and forth, the Ninth Circuit has once again weighed in, and the outcome could shape Second Amendment law for an entire generation. Scale Part 2. The battle over large-capacity magazines. The heart of Duncan versus Bonta isn't just about magazines. It's about how far a government can go in redefining what the Second Amendment protects. California calls them large-capacity magazines. But for millions of gun owners nationwide, these are standard 15-round magazines for a Glock 19, 30-round magazines for an AR-15, and so on. The state argues that limiting capacity makes mass shootings less deadly. But plaintiffs argue the opposite, that these restrictions disarm citizens in the most critical moments of self-defense. Judge Benitez, in his most recent ruling, made a point that resonated deeply. The state cannot ban the most commonly owned firearm hardware in the country and still claim to be respecting the Second Amendment. But when the Ninth Circuit reviewed his decision, a divided panel disagreed. The majority claimed that magazines are not, in themselves, arms, but rather accessories. In their view, a firearm without a magazine can still exist. Therefore, magazines fall outside the core protection of the Second Amendment. This reasoning has sparked outrage across the gun community. Legal scholars, former prosecutors, and constitutional advocates have all said the same thing. A firearm without a magazine is like a car without fuel, technically present, but functionally useless. The dissenting judges, including Judge Van Dyke and Judge Bumate, agreed with that logic, warning that the majority's reasoning is not only legally weak, but dangerous. Judge Bumate wrote, "When the Constitution guarantees the right to keep and bear arms, it includes the functional arms necessary for that right to have meaning." And with that, the battle lines were drawn once again, with both sides knowing the next stop could be the Supreme Court. Part 3. The Ninth Circuit's reversal and the controversy behind it. When the Ninth Circuit handed down its latest decision in Duncan versus Bonta, it didn't just reverse Judge Benitez's ruling. It reignited one of the most polarizing debates in the country. In a 2-1 decision, the panel reinstated California's magazine ban, ruling that it was consistent with the nation's historical tradition of firearm regulation. But here's where things get complicated. The court cited 19th century laws that restricted dangerous and unusual weapons, things like Bowie knives or early multi-shot firearms, and argued that such analogs justified modern capacity limits. The problem? Those historical analogs were rare, isolated, and often rejected by courts even in their own time. The dissenting opinion pointed out that by using fringe examples, the majority had essentially rewritten the Bruen test to fit a political conclusion rather than a historical one. Judge Van Dyke, writing in dissent, went further. This court continues to twist itself into knots to uphold every gun restriction that crosses its path. The result is a patchwork of opinions designed to erode the Second Amendment one piece at a time. His message was clear: this wasn't about history. It was about control. And that's why the Supreme Court is now watching Duncan versus Bonta closely. Because if this logic stands, it means any state can repackage a gun ban as a safety measure and claim historical precedent, even when none exists. Scale Part 4. The constitutional question: what counts as an arm? The deeper question behind Duncan versus Bonta is this: what exactly does the Second Amendment protect? The text is clear. The right of the people to keep and bear arms shall not be infringed. But does arms mean the firearm itself? Or does it include the components necessary for that firearm to function effectively, like a magazine? For decades, courts have danced around this question. But after the Supreme Court's Heller and Bruen decisions, the answer is leaning heavily toward inclusion. Justice Scalia's opinion in Heller said the Second Amendment protects all arms, in common use, for lawful purposes. Magazines holding more than 10 rounds easily meet that standard. They're owned by tens of millions of Americans and come standard with many of the most common handguns and rifles. In other words, they're not dangerous and unusual. They're normal. The state's argument that these magazines make weapons too deadly ignores a simple fact. A firearm without a functioning magazine cannot serve its defensive purpose. And that's exactly why gun rights advocates say this case is so important. If the courts can redefine a magazine as an accessory, what's next? Sights, triggers, ammunition? The Duncan case isn't just about capacity. It's about the government's power to slice the Second Amendment into meaningless parts. That's why every major 2A organization in the country, from the NRA to Gun Owners of America, is lining up behind this case. Because if the Supreme Court doesn't intervene, the precedent could hollow out the right to bear arms piece by piece. Part 5. The Bruen Test and the Battle over History. In 2022, the Supreme Court's Bruen decision changed everything. It struck down New York's restrictive carry law and established a new test. Any modern gun regulation must be consistent with the text, history, and tradition of the Second Amendment. That meant courts could no longer rely on interest balancing, the idea that a government's desire for safety could outweigh your rights. Instead, they had to prove that a similar restriction existed in America's founding era. Judge Benitez applied that test in Duncan versus Bonta. He found no historical precedent for banning commonly used magazines. None. The Ninth Circuit majority, however, reinterpreted the Bruen test in a way many experts call a distortion. They argued that even if no direct historical match exists, the principle of regulating dangerous weapons still applies. That's not what Bruen said. Justice Thomas wrote that analogs must be relevantly similar, not vaguely comparable. You can't point to a 19th century knife ban and use it to justify disarming millions of modern Americans. This is why the Supreme Court is likely to step in. The justices have already signaled frustration with lower courts twisting Bruen. They've vacated and remanded multiple cases for ignoring its standard. And when they finally address Duncan versus Bonta, it won't just be about magazines. It will be about the future of the Second Amendment test itself, and whether lower courts can keep redefining history to fit modern politics. Balance Scale Part 6. Ripple Effects for States and Federal Courts. The Ninth Circuit's decision doesn't just affect California. It sends shockwaves across every state still enforcing magazine bans: New York, New Jersey, Illinois, Hawaii, Maryland, and a handful of others. Each of these states passed laws almost identical to California's, relying on the same public safety arguments. But now, with Duncan versus Bonta positioned for Supreme Court review, every one of those laws is on unstable ground. If the Supreme Court grants certiorari, and all signs suggest it might. We could be looking at a ruling that applies nationwide. That means the end of magazine bans, not just in one state, but across all 50. Legal analysts are already calling this the Bruen sequel. Because just like Bruen redefined carry laws, Duncan could redefine what counts as a protected arm. Federal courts are also taking note. District judges in Colorado and Washington have already paused or questioned local magazine restrictions, citing the need to wait for the Duncan outcome. In other words, Duncan versus Bonta isn't just a California case anymore. It's the test case for the entire nation. And the ruling will either restore the Second Amendment to its full intent or give states a roadmap to keep chipping away at it, one magazine at a time. On scale Part 7, the gun owner's reality check. It's easy to celebrate every legal victory, but this is also a moment for realism. Gun owners need to understand. While the courts debate these questions, states are still enforcing their bans. Thousands of people are currently at risk of prosecution simply for owning equipment that's legal in 40 other states. That means the fight isn't over. Not by a long shot. Until the Supreme Court steps in, responsible gun owners need to stay vigilant. Know the laws in your state, understand your rights, and prepare for change. This is also a reminder that rights are never self-executing. They have to be defended, challenged, and reaffirmed generation after generation. That's what makes cases like Duncan versus Bonta so critical. It's not just about equipment. It's about principle. The government doesn't get to decide how many rounds you need. The Bill of Rights isn't about need. It's about limits on government power. And as long as those limits are under attack, education and awareness are just as important as the firearms themselves. Because freedom only survives when the people understand it. Balance Scale Part 8, the Second and Fourth Amendments, a united defense. What's fascinating about this era of litigation is how the Second and Fourth Amendments are beginning to overlap. In Barnes versus Felix, the Supreme Court tied together the right to self-defense with the right to be free from unreasonable searches and seizures. Now, with Duncan versus Bonta, that connection becomes even clearer. Both amendments exist to limit government intrusion, one into your home and one into your ability to defend it. When the government tells you what kind of magazine you can own or how you can carry your firearm, it's not just a Second Amendment issue. It's also a Fourth Amendment question of personal autonomy. Because if the state can define your need, it can also decide what kind of security you're allowed to have. That's the deeper constitutional reality. The Second Amendment doesn't stand alone. It's part of a larger structure that protects privacy, liberty, and personal sovereignty. That's why every major Supreme Court ruling in this area, from Heller to McDonald to Bruen, has also reaffirmed broader principles of personal freedom. So when you defend the Second Amendment, you're defending the foundation of every other right that depends on it. Balance Scale Part 9, what this means going forward. So what happens next? California's Attorney General, Rob Bonta, has already vowed to defend the magazine ban all the way to the Supreme Court. Petitions are being prepared, amicus briefs are being filed, and millions of gun owners are watching, waiting for the justices to make their move. If the court takes the case, and history suggests they will, Duncan versus Bonta could become one of the defining rulings of this decade. A victory for Duncan would mean a nationwide precedent that reaffirms the right to own standard capacity magazines as a core part of the Second Amendment. A loss, however, would give states a green light to regulate almost any firearm component under the vague label of public safety. Either way, this decision will define how far the government can go in restricting your right to keep and bear arms. And that's why this moment matters. Because the future of gun rights won't be decided in a headline or on social media, it'll be decided in a courtroom. As this case moves toward the Supreme Court, remember, rights are not gifts from government. They're boundaries against it. This is Firearms Explained, where we break down the law, defend the truth, and protect your liberty through understanding. Stay informed, stay prepared, and stay free.